Hello, this is Matt on the Moon Lambo channel. Just a few hours ago, attorney Jeremy Hogan shared some late-night thoughts all up on the Twitters regarding what he thinks takes away from Ripple's argument in the SEC v. Ripple case as it may pertain to other circumstances, and you'll see what I mean by the end of this video. And so his thread starts off as a really interesting, just kind of a history lesson in a way, in terms of what actually happened like in the actual Howey test regarding the 1946 Supreme Court case. And that's something that we haven't really broken down in great detail in a while here, so it's always good to have that as a refresher, but it's important to make sure that you have that as an understanding so that he can articulate his ideas as to why certain things may be problematic depending on how it's applied to certain circumstances moving forward. Now, this doesn't necessarily mean that there's something specifically wrong with Ripple's arguments as applied to this case. But again, just hang with me. I think you're going to find this fascinating, and by the end of the video, I hope it's all clear. And I think I have a pretty reasonable interpretation of what he's trying to say at this point, because at first I was like, wait, what did he say? And then I had to read it another time, and I saw other people had some similar questions to what I was initially thinking, but I think I've gotten to the bottom of it. So before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Oh, and by the way, I wanted to mention this at the outset of the video as well. There's a Ripple employee who actually responded to attorney Jeremy Hogan's thread and had some feedback on this. And this particular employee is actually, I believe he's a software engineer who works on Ripple's on-demand liquidity. So interesting stuff. But here's what attorney Jeremy Hogan had to say. Ripple argued that XRP is not a security because it has no post-sale obligations to purchasers. What was the post-sale obligation in Howey? And I'll just pause to note, there was one. So this is a clear distinction. It's not that Jeremy Hogan in this particular thread is saying that Ripple's made a bad argument. That's not the point, but just hang with me, and again, you'll see what I'm talking about. And then Jeremy says, in Howey, the defendant sold small plots of orange groves to investors, and that would have been fine if that's all they had done. And I'll just pause to note, that shouldn't surprise anybody. If you're just talking about the sale of land, that's not some sort of scheme of an investment contract or anything of the sort. That's sale of a plot of land that has orange groves. So that by itself would not have caught the attention of the SEC, but that's not all that happened. Attorney Hogan continues. But then, after the purchase of the plots, the investors then turned around and entered into an optional 10-year lease service agreement contract with defendant's affiliate, allowing the affiliate to manage the grove as an entire unit and distribute profits back to investors. It was that pooling of money and management of the groves as one unit which was the pooling of money and the common enterprise we hear about in the Howey case. But it was the lease service agreement that was the post-sale obligation. And so, pause note here, you may have already sniffed this out on your own. No such thing exists with the sale of XRP, certainly not with direct sales from Ripple to strategic key partners, and certainly not on secondary markets. But anyway, attorney Hogan continues. The Howey affiliate had to maintain those groves and distribute profits back to the investors or risk being sued. And that obligation to distribute profits is what is missing in Ripple's case. Now, sometimes the legal discussion becomes about utility, because there are some cases which look at marginal situations and rely on whether the purchase, i.e. the land, was bought as an investment or to use. Did you really buy the land to go down and pick oranges in the summer? Let's just pause here. Plug in XRP for that, though. Because think about that. Did you really buy the XRP to use it for any sort of utility purposes? And see, it depends. So you can argue the utility side of this, and that's why for me, I mean, my personal answer to that is I did buy it as, a financial speculative tool, effectively. That's it. I'm speculating, but it's not because of Ripple specifically. That was a part of what I was factoring. I've been talking about this for almost 5 years at this point, though. It's more about confidence in the ecosystem, and yeah, Ripple's a big player in that. But to what degree does that actually matter? And so what you can see what the SEC would perhaps argue here is that Because again, the point being here is, as Jeremy Hogan stated it, did you really buy if in the Howie case, did you really buy the land to go down and pick oranges in the summer? So the point is, would those people have even purchased it if not for the rest of the scheme? So this is, can you see, and that's why I wanted to pause to talk about this. Can you see how the SEC can be arguing something like that? But you wouldn't have even purchased the XRP if not for the fact that there was this bigger scheme. That's what they're arguing. I'm not saying I agree with it, but I'm saying that's the argument. And so likewise here, okay, would you have actually bought the land, to pick oranges in the summer for the utility of it? Would you really have done that if not for the rest of the scheme that was going on? And the SEC's approach to that back in the 40s still was obviously no. Anyway, Attorney Hogan continues. The library case judge in briefing was apparently very focused on the utility of the token, with the SEC arguing that even if 1 million people bought the library token to use it, and one person bought it as an investment only, equals security. Expect to see that decision this week. Yeah, so I'll pause to note, we initially were supposed to get that ruling. When was it? Like, not this past Friday, but the one before that. That was a self-imposed deadline by the judge, and we've still seen nothing. And by the way, if there is no summary judgment, which is a possibility, although I don't know that it's likely, the trial is going to start October 3rd. So we're going to have an answer very, very soon. I'm still anticipating, if I had to guess, and I don't have to guess, but I'm willing to guess on my channel. It's my channel, damn it, I do what I want, and I want to guess. I would say there's going to be a summary judgment. I don't know exactly how it's going to break down. I don't pretend to. I'm just cautiously optimistic, but that's a coming soon. And then Attorney Hogan says, which, in conclusion, makes me nervous when I see new crypto projects being set up into 2 steps. First, the sale of an NFT, which then gives purchasers access to a second step, which somehow allows the purchase of the token. This is popular recently, and I'm going to circle back to that because the first time I read that, I was like, wait a minute, and then I just kept going through, and then I circled back, and I was like, okay, it's making more sense now. And then he wrapped up his thread by saying, this is concerning because it seems clever, but it takes away both Ripple's argument that the token was a sale of an asset and Library's argument that the token is a utility token. Just some late night ramblings while the kids are sleeping. Good night. So a couple things on this. There was a tweet that I came across from somebody named Crypto with a K at AJBogan52. And he wrote to Attorney Hogan sharing some thoughts, and he said, the sale of XRP still doesn't constitute a contract. I think he meant contract. I have been buying XRP for over 6 years. I have no contract, nor was ever asked about whether or not I wanted one. Yeah, so obviously, just to be clear, in terms of what Attorney Hogan was stating, he's saying, as precedent setting as the Ripple case will be, and library, all that, moving forward, these arguments, it's kind of questionable how they'll apply, but in terms of constituting in a contract, that part of the equation hasn't changed, and we know now that that's a big part of what Ripple is arguing in their motion for summary judgment. So that to this point is unaffected by this point. That's a separate topic, so I did want to point that out just to be clear. Now, additionally, there is a Ripple employee named Neil Hartner, who you can see self-described in his bio here, software engineer at Ripple working on RippleNet ODL, curious about stocks and crypto. And so he wrote to Attorney Hogan, shared the following. I see projects like Utes, where you buy a tube NFT whose only utility is to later mint an art NFT from the same issuer. Seems to satisfy the Howey test, especially if view the first NFT as an investment contract to pay for the development and delivery of the art NFT. So there you go. And upon reading that, I was like, yep, that's exactly what's going on. So think about this. I'm going to try and break it down because it might sound confusing to this point. Consider if you were going to purchase an NFT on the Ethereum blockchain. Well, first what you do is you purchase some ETH, and then you'd use that ETH to purchase the NFT. Now, that is, and by the way, I'll mention that. That's presumably how things would be set up. Like if we get the XLS 20 amendment passed, where there's additional NFT functionality native to layer 1 of the XRP ledger, presumably, I don't know if there would be any exceptions to this, but it would work in a similar function. You can utilize XRP for the same purpose, which is, of course, native to the XRP ledger. So the reason I want to say that, though, is because utilizing ETH to purchase an NFT, that's exactly backwards from what Jeremy Hogan was talking about here. What he's talking about here is you make a purchase of something, and then you use that thing that you purchased, which is an NFT, in order to mint tokens in the future, which would be NFTs. And so that's why, again, let me read Neil's response to that, because I just felt like that was really hitting the nail on the head. So again, Neil Hartner to Jeremy Hogan wrote, I see projects like Utes where you buy a tube NFT whose only utility is to later mint an art NFT from the same issuer. Seems to satisfy the Howey test, especially if view the first NFT as an investment contract to pay for the development and delivery of an art NFT. So you can think about that if you try and compare it to like what happened in the actual Howey case. This is my, I don't have a legal background, so just the way that I'm interpreting it, hopefully correctly, but it sounds like, so that first purchase, in the NFT, which is separate so that you can get tokens later, that first purchase sounds like kind of like the purchase of the land, and then all of the real investment comes from what's on top of that, the orange grove. So in this case, purchasing tokens utilizing the original NFT purchase. That's what it sounds like to me. And if anybody has a different interpretation of that, if you think I got it wrong, let me know. But upon spending a little bit of time here reading through some of the comments here, I think that's what is being pointed out here. That seems to make sense to me. And so again, when Attorney Hogan wrapped up his thread by stating the following, it all came together. Here, I'll just read the last two tweets because they go together like spaghetti and meatball. Check this out. Which, in conclusion, makes me nervous when I see new crypto projects being set up in two steps. First, the sale of an NFT, which then gives purchasers access to a second step, which somehow allows the purchase of the token. This is popular recently. This is concerning because it seems clever, but it takes away both Ripple's argument that the token was a sale of an asset and Library's argument that the token is a utility token. Just some late night ramblings while the kids are sleeping good night. See, and so this is a different setup, obviously, than what is happening in the SEC v. Ripple case. And I just want to state also, again, to be clear, and the reason I went through that more than once is because I think repetition is useful for something like this, which is sharing somewhat complex ideas that many people probably aren't familiar with. But I don't think that this is going to impact anything with XLS20. There's no indication of that, assuming that amendment ultimately gets reassessed and passed. I certainly don't anticipate that. But it's interesting because even, like I said, even as precedent-setting as the Library case and Ripple cases undoubtedly will be, it doesn't mean that there can't be some serious hardships for other projects moving forward. And it seems to me that's what Attorney Hogan was really getting at there. So let me know what you think in the comment section below. Did I get it right? Did I completely blow it? I love your feedback. Be nice, please. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.